Good morning, everybody. Thank you very much for coming on short notice. We got a number of media requests and comments from the general public about what we could possibly do to reverse this quite frankly outrageous and completely ill-advised action by the federal government to through the sequestration process to effectively eliminate our air traffic controller service at our Cuyahoga County Airport. As I said before, when these cuts were first announced, this is a key driver of our local economy. There's over $150 million worth of economic activity that is based around the airport. There are a couple thousand employees. There are 54 businesses, everything from the ones you might have heard of that are actually things like flight options that are actually conducting the flights out of there, to smaller businesses that people may not have heard of, but they're important for the people that own those businesses and that are employed by those businesses. So it's essential that we maintain this as a viable airport. And it is an airport and an asset that is helping us compete economically really across the whole world, but also regionally and across the country. When this was first announced, I asked my law department if there were any legal options whatsoever that we could pursue to try to at least delay this very ill-advised action by the FAA and the federal government. I'm standing here today with my law director, Majid Makhlouf, and I'm going to talk and have him talk a little bit about what we are filing. But basically, we're filing a legal action seeking a stay and appealing administratively the action of the FAA, and it's based on a number of grounds. And if I had to kind of boil down what the theory of our case is that the FAA is not really following its own policies. There's a fundamental mission, which is the fundamental mission of the FAA is to provide for aviation safety. To pull these air traffic controllers out in this very arbitrary and abrupt manner is something that has an effect on public safety. And the FAA administrator is required by statute to make a public interest determination before that decision is made, and we don't believe that that process has been followed. There is a formal safety risk management process that the FAA is supposed to go through before a closure of this type takes place. There's something called a safety management review. We don't believe that that process was followed. These processes, by the way, were established just so that these types of actions could be avoided. When it comes to public safety, especially with aviation, you don't want a government entity doing things in an arbitrary or capricious way in a manner that could affect public safety, and we believe that this is happening here. There shouldn't be any doubt, by the way, that this is a major provider of flight services in this area. And not only the flights that are taking off and landing at the Cuyahoga County Airport, but we also act as a reliever airport as well for Hopkins. There's also another provision of federal regulations which requires the FAA to perform what's called a National Environmental Practices Act assessment when a closure is proposed by the federal government. Basically, what we know as a fact is that flight operations do have an environmental impact. The flights that are currently taking off and landing at Cuyahoga County Airport have to go somewhere, and that means that air traffic will increase somewhere else, and that has environmental effects. And we also believe that the FAA failed in their duty to do that necessary environmental assessment. And then lastly, I would note that there's supposed to be a cost-benefit analysis that under the CFR, which is Code of Federal Regulations, the FAA is required, now I want to underline that they are required to conduct a cost-benefit analysis, and I'm going to quote, that whether or not the continued operation and maintenance cost less termination costs of the airport traffic towers exceed the present value. So in other words, does this make economic sense? And I think we can make a very strong case that this doesn't make economic sense. And I guess that's really our whole point here is there doesn't seem to have been much thinking or analysis at all when it comes to this decision. It's very hard to defend this decision on economic grounds, on safety grounds, on policy grounds, on environmental grounds. So we're going to be filing this. I'm going to have Law Director Majid Makhlouf talk about where the action is being filed and a little bit more about the specifics of the legal action itself. Law Director Makhlouf, go ahead.
Thank you very much. We are going to be doing two things today. Number one is we're going to be submitting a request for stay with the Federal Administration, with the Federal Aviation Administration today, seeking a stay pending the legal action, and then we're going to be filing a petition for review of the FAA's decision with the U.S. Court of Appeals for the District of Columbia Circuit. The legal arguments that the executive went through are exactly correct. The FAA has to go through certain procedures and do them in a reasonable manner before taking a decision. It doesn't look like they did any process, let alone a reasonable process, what they did here. This airport has 44,000 touchdowns and flights every year. You add an additional 6,000 flights that traverse the airport that are for life flights and for safety flights that don't touch down, but they traverse the airport and are assisted by the tower operators. One mistake is too many. And I think had the FAA done the mandatory safety assessment that they have to do under federal law, they would have caught those things. They would have not put our airport on the closure list. And more importantly, our airport was open before 1987, so by federal law, they cannot close it, and that's part of our appeal. And I'll leave it at that.
I would just add this, is when we first got notice of this decision, the commitment that we made was that we were going to pursue absolutely every avenue. And this is one avenue that we've come up with. Now, we've gone to Washington. We have pleaded with the FAA, and those appeals have fallen on deaf ears. We have asked our congressional representatives, and they have responded, and they have tried. But what you've seen in this type of decision-making is basically a substitute for thinking. There is no analysis that we've seen here. It makes no sense on economic or public safety grounds, and we're stuck with the results of this just completely arbitrary, unthinking approach. And I said at the time when we heard about it that we were angry about it because we have to make decisions in our daily lives and as a government entity that on budgetary matters that make sense. And we have a responsibility as public officials to try to minimize the harm to the public whenever possible. We do that at the county level. They need to do the same thing at the federal government level. And the nice thing is, and it's what this legal action includes this argument, is they're required by law to do so. So even if common sense didn't prevail or good judgment didn't prevail, which apparently it hasn't, hopefully just following the law and following their own code of federal regulations will at least grant us a stay until cooler heads can prevail in Washington and they can start funding things in the manner that they have already committed to do so in the past. Well, thank you very much for coming. I appreciate it, and we'll let you know if there's any more updates about this as the case proceeds. Thank you very much. Thanks for coming on short notice.